Thank you. Now, I'm really an outsider compared to the speakers and presumably the audience who is here in the room. I would like to start by saying thank you to the organizers of this conference, in particular to Secretary of State Bogdan Aurescu, who kindly invited us to participate. And before I actually proceed with my presentation, I would like to say a few words about a thing which came to my mind listening to Sir Michael Wood and after that to Professor Mazilu. They brought back a very emotional and personal experience to me because I remember very well what December '89 meant to Romania. And I remember as a youth listening to the Western stations, radio stations broadcasting in Romania. That was about the Romanian press of those days. There was no other free Romanian press other than those stations, and they were speaking all the time about the Mazilu case. I think that one of your questions was, what was the practical effect of the decision rendered in the case of Professor Mazilu? I think that there was at least a very practical effect. People in Romania knew about this case, knew about one name, and there weren't too many at the time, unfortunately, too many names resisting the communist regime and doing it openly in the way Professor Mazilu did it. And I think that that was an important factor which contributed to the build-up, which resulted eventually in the Romanian Revolution and the events of December '89, as many people like to call them nowadays. So again, thank you for bringing that back to us. And I personally, I'm very happy to have had this opportunity to listen to you. Now, the more technical part of my speech relates to the bilateral investment treaties and a part, or at least, of the experience which Romania got in dealing with arbitration started under those investment treaties. Typically, bilateral investment treaties, also known as BITs, are instruments of international law which include guarantees of appropriate compensation for expropriation, undertakings to abstain from unreasonable and discriminatory measures, guarantee of national treatment of the investment, promises of fair and equitable treatment, commitments that investment will receive full protection and security, undertakings that a sovereign will honor its obligations, and assurances that investment will receive treatment no less favorable than that accorded to investors or to any third states and their investment. In other words, the most favored nation treatment. Romania has concluded its first BIT in 1976 with the United Kingdom, while the last one, which became effective, has been concluded with Canada in 2009, replacing an older agreement of 1996. Out of the BITs concluded by Romania, a number of approximately 80 are still valid. 63 of them concluded with countries which are not members of the European Union have been notified to the European Commission in 2013 and shall be maintained in principle in force until such time when replaced by a common European BIT concluded with each of these countries, or, as the case may be, until they reach the natural date of their expiration. A central feature of the BITs is the provision of procedural rights, typically the entitlement to submit investment-related disputes to arbitration. Investors thus often have an agreed and relatively convenient forum to enforce their substantive rights. In addition, many BITs offer investors a certain choice as to which arbitration regime to use, and most BITs permit inter alia arbitration before the World Bank's International Center for the Settlement of Investment Dispute. In recent years, there has been a significant surge in the number of such BIT arbitrations. Thus far, a number of 278 cases have been settled only under the ICSID rules, and an additional 183 cases are still pending. And again, we are talking about cases which are settled or to be settled under the ICSID rules. We are not including here in the statistics cases which are litigated in other fora, such as under the UNCITRAL rules, which fortunately or unfortunately are much less open to such kind of statistics. Generally, arbitration performed or conducted under the UNCITRAL rules are confidential. More than 2/3 of the total ICSID arbitrations have been initiated in the last 10 years, and several pending claims have been valued in excess of $100 million. Most of the treaties allow investors, besides recourse to ICSID arbitration, to choose between litigating their treaty claims in national courts or arbitrating their investment claims before an arbitral panel in a neutral forum, such as provided under the arbitration rules of the International Chamber of Commerce, or ad hoc arbitration operating, as I said earlier, under the rules of the United Nations Commissions on International Trade Law, UNCITRAL. In BITs concluded before 1989, Romania has been in general unwilling to submit the settlement of disputes to the jurisdiction of international arbitral tribunals. With the sudden opening of the country to foreign direct investment after 1990, the government's outlook became much more permissive, and arbitration clauses have been accepted. The first prominent example in this direction is the BIT concluded with Italy on the 6th of December 1990. The ability of foreign investors to resort to international arbitration has been further recognized within the domestic legal system in 1997 in legislation regarding stimulus for investment. Even though Romania has become a party to the ICSID Convention on the settlement of the investment disputes between states and nationals of other states in 1975, the first ICSID case has been filed against Romania only in 2001. So far, there have been a total of 7 completed BIT cases against Romania. The first one was the Noble Ventures case, initiated in 2001, concluded in 2005. And there are also other cases. The most recently finalized case is the so-called Bicula case, which resulted in an award issued in December 2013. One additional and lesser-known BIT case against Romania has been filed under the UNCITRAL rules based on the provisions of the BIT between Romania and Poland, and has been settled amicably by the parties in 2004. There are also 2 pending BIT cases against our government. No less than 7 out of these cases have arisen in connection with privatization-related matters. Romania has been successful in a large majority of these cases. Apart from the case which was settled amicably, mentioned earlier, 5 cases to date have been won. The Rompetrol case, one of those cases, has been lost in part on liability, but won by Romania on quantum. The arbitration award not giving any damages to the claimant, while in the most recently finalized case, the Bicula case, Romania lost both on liability and partly on quantum, resulting in an award of approximately $116 million, which computed together with interest, it seems that it results in an amount of about $250 million, which is a major blow to the budget. Fortunately, again, or unfortunately, it didn't make the headlines of the press in Romania, but still, it's a major blow to Romania's budget, which is already stretched very thin. There have been a number of recurrent issues discussed in those arbitrations, among which I selected for this presentation a few, which look capable to generate difficult legal discussions in the future. The main issues which I will continue to discuss concern the sphere of the investors protected under the BITs, the legitimate expectations of investors, which is a very sensitive subject, especially in a country for Romania, which is not very famous for the stable legal and economical environment which offers to investment and to investors. The situations of BITs concluded between countries of the European Union, and BITs concluded with non-European Union members. About the investors which are protected under Romania's bilateral investment treaties, first, I would like to mention the fact that there are basically two model BITs in use, namely the so-called European model based on the EBS-Shokros Draft Convention model endorsed by OECD ministers in 1962, and the so-called North American model developed in the early 1980s. The main distinction between the two models is that the former mainly applies to the post-entry phase, while the latter also covers investment at the pre-establishment phase. Without entering into much details on this, I would like only to mention that the vast majority of Romania's BIT offer protection for investments made after the date those BITs become effective, and a notable exception in that regard is 2009 BIT concluded with Canada, which, in the same manner as its predecessor of 1996, protects also already existing investment at the date of the entry in force of the relevant BIT. The same government ordinance of 1997 on investment, which I mentioned above, provides for a definition of investment which is narrower than that which is found in the majority of the BITs concluded by Romania, and covers in general the establishment of companies and branches of foreign companies and the acquisition of shares in commercial companies. By contrast, one of the most important BITs of Romania, and I'm saying one of the most important because it seems that this is the country with the largest foreign direct investment in Romania, which is the Netherlands, encompasses within the notion of investment not only the acquisition of shares, but also any ownership rights, intellectual property rights, rights derived from public law contracts, including concessions on natural resources. While the specific wording used may differ from one BIT to another, the fact remains that under the international law, the notion of investor is broader than its meaning described in the domestic legislation of Romania. BITs are typically designed to protect individuals or companies of one contracting party which choose to invest in the other signatory country. However, in the current stage of globalization, national boundaries have become more and more blurred for international companies, while affluent individuals may move easily from one country to another. All this renders sometimes difficult the application of the seemingly straightforward rules on nationality provided within the BITs. And more opportunities are created for the so-called forum shopping, which in this context describes situations in which investors having ultimately the same nationality as the respondent state in the arbitration, or having the nationality of the state with no or insufficient protection of a BIT, seek to use the provisions of a more advantageous treaty. Actually, in a significant number of cases involving Romania, the ultimate shareholders of corporate claimants were actually Romanian nationals, while in at least other cases, the claimants who acted as individuals held dual citizenship, including Romanian. In this context, the recent Micula Award seems to attest to the advantages of being a foreigner eligible for BIT protection rather than a domestic investor subject only to domestic law protections. Indeed, the competitive fairness of compensating the Swedish investors at a time when others would not be eligible for such compensation or aid was a major concern raised even by the European Commission in its amicus curiae intervention in the arbitration. It is time now to discuss an issue which presents particular difficulties, as I said, in a country like Romania, that of legitimate expectation which foreign investors may claim to have in relation with the business, economic, and legal environment prevailing around them in the country. Even though after the accession to the European Union, Romania has become much more stable than before, the country remains prone to a greater degree of instability and regulatory change than its counterparts in Western Europe. In this context, again, a brief review of the salient facts of the Micula case may be instructive. Romania passed an ordinance in 1998 that made available certain incentives, including tax incentives and exceptions from custom duties levied on raw materials and important equipment, which were applicable to investors involved in so-called disfavored areas. In order to benefit from those incentives, three corporate claimants of the Micula group of companies obtained so-called permanent investor certificates as was required under a set of norms issued in 1999. The norms expressly designated the relevant region of Romania, which was placed in the Bihor County, as a disfavored one, for which incentives would be granted for a period of 10 years. At the same time that Romania was offering incentives to these companies, and not only to them, ties between Romania and the European Union were deepening. Indeed, Romania and the EU had concluded an agreement as far back as 1995, the so-called Europe Agreement, that had established an association. A formal accession process began in February 2000 and culminated in the accession of Romania to the European Union in 2007. As the talks regarding the accession unfolded, Romania found itself under growing pressure from the European Union to align its incentives programs with the European Union laws designed to promote competition and to limit the granting of so-called state aid to business interests. In February 2005, all but one of the incentives to disfavored areas were revoked earlier than the originally promised 10-year incentive period. When it came to the fair and equitable treatment obligation included in the BIT between Romania and Sweden, the arbitral tribunal ruling by majority concluded that Romania had created the legitimate expectation that the incentives would remain in substantially the same form over a 10-year period. Thus, when Romania later revoked some of the incentives prematurely in 2005, in an effort to appease the European Union, this tribunal majority held that the revocation triggered a breach of the fair and equitable treatment obligation. The tribunal in the Micula case contended that the standard of fair and equitable treatment offers some stability, while not outright stabilization in regard of the legal regime applicable to foreign investment, insofar as investors should expect that states will not violate legitimate expectations or engage in substantively or procedurally improper action. With respect to legitimate expectation, the tribunal held that there must be a promise or assurance and that it is irrelevant whether the state in fact wished to commit itself. What matters is that the state acted in a manner that would reasonably be understood to create such an appearance. The tribunal determined that Romania instilled in the claimants a legitimate expectation that they would receive the relevant incentives for a period of 10 years in substantially the same form. The arbitrators went on to determine that this expectation that the incentives will last until 2009 was reasonable, as seen against the backdrop of Romanian law, as well in the context of Romania's EU accession. In fact, the tribunal noted that even the country's president had publicly commented that the investors would be compensated if the incentives needed to be withdrawn prematurely. In actual fact, the claimants were not compensated when incentives had been revoked. The European Commission has a relatively recent history of aversion against bilateral investment treaties concluded between member states. Before 2004, there was little need to address this issue, since by that time only 2 BITs had been concluded between member states. However, with the new waves of accessions to the European Union in 2004 and 2007, the number of the intra-EU BITs abruptly increased to about 190. Already during accession of new member states in 2004, the European Commission raised concerns about the bilateral investment treaties that European member states had signed with the newcomers. Sparing you of the details regarding the history of these discussions, I just like to note that insofar as this discussion arises in arbitration, in BIT arbitrations, the concerns of the commissions have been met with very little sympathy by the arbitrators. The arbitral tribunals in various BIT cases have held that BIT arbitration clauses are neither superseded or otherwise restricted by European Union law. In the respect of extra-European Union BITs concluded between a member state and states outside the European Union, the European Commission passed a regulation in late 2012, which established transitional arrangements for bilateral investment agreements between member states and third countries, and which confirmed the validity of extra-EU BITs signed before December 2009. This is a key date because after that date, the European Union has, pursuant to the Lisbon Treaty, competences within the investment policy of the European Union, a thing which it did not possess before that. The regulation creates a regime whereby extra-European BITs signed between 1 December 2009 and 9 January 2013, the effective date of the regulation, may be maintained or enter into force subject to certain conditions. And third, it establishes a framework whereby member states may negotiate or enter into new extra-European Union BITs in the future. The intention of the European Union is to include the negotiations of the BITs in the more general framework of negotiations with other countries, and it seems that the more advanced negotiations in these directions are the negotiations with Canada, which would result in provisions which also cover the settlement of investment disputes with investors between the two regions, Canada and European Union. In our experience, it was many times difficult to make state institutions grasp the idea of them being responsible under international law, even in situations where it looks obvious to them that they acted in a context which was purely of domestic law. In practice, apart from a select few, the provisions of the BITs are largely ignored by the people working in various branches of the government. They usually give reference to whatever specific norms are applicable to their field of activity and remain quasi-ignorant of the more general principles enshrined in instruments of international law providing for investment promotion and protection. If a BIT case eventually occurs, the state institutions tend to respond relatively late, and it still takes time for them to understand the requirement to justify their actions or omissions, not only in the context of domestic legislation, but also against the background of the substantive provisions in the BITs. I'm running out of time, I believe. Okay, 1 or 2 minutes. In the EDF services, a few words about attribution. In the EDF Services Limited versus Romania case, one of the issues discussed by the parties has been the attribution of various acts of commercial companies held by the state, but whose corporate bodies, including the General Meeting of Shareholders and Board of Directors, acted under strict instructions issued generally in the form of written mandates by the Ministry of Transport. Normally, irrespective of their form of ownership, commercial companies under Romanian law are regarded as private actors, with separate legal personality from that of the government, which means that, as a principle, their actions may not be attributed to the state. In this case, however, the arbitral tribunal concluded that the conduct of those companies was attributable to Romania based on the recognition of the fact that they operated under the direction and control of the state. In the Noble Ventures case, a case which was very interesting because, as I said, it was the first case dealt by Romania under a BIT. It was the BIT with the United States, and it was a very sensitive time for Romania. And I remember a gentleman saying to me at that time, it was before NATO accession, it was before European Union accession, and that gentleman told me, well, you should be very careful about this case, because if there will be a reason for Romania not acceding NATO, will be the loss of this case. Fortunately, the case was won, and Romania made it to the NATO. I don't know, still don't know if there was actually a connection between the two, but everybody was very emotional at that time about the existence of that case. In that particular case, in the regard of attribution, we had a very interesting discussion regarding the State Ownership Fund, Romania's privatization authority, at the time of the most relevant facts for the case. which was held to be in the same position as a government ministry, even if it had as its main job the sale of participation of the state in commercial companies, which was effected through the conclusion of sale purchase agreement, which were submitted to private law, to civil law. I think that Romania is, and for the foreseeable future, will remain a country who will be rather a destination for foreign investment, rather than an exporter of investment. It is therefore likely that the government will continue to be exposed to claims by disgruntled investors and will continue to face the risk of being ordered to pay enormous monetary compensation for actual or speculative damage suffered by investors, even in situations in which measures affecting investors may be based on generous considerations of public good, protection of environment, or enforcement of legal rights conferred by the applicable domestic legislation. Far from inhibiting the government from action, all this should be regarded as an invitation to better regulation, more consistent and predictable enforcement of legislation, a very important point, which is unfortunately ignored in practice, and of course improved support for investment and job creation in Romania.